Good morning, everyone. Welcome to our Business Contract Principles with Ty Zeller. Ty is a certified business advisor here at the University of Houston-Victoria Small Business Development Center. And you are here for the principles of business contracts. So I want to thank everybody for joining us today. I am Jean Smith. I am the training coordinator with the University of Houston-Victoria Small Business Development Center. We are recording today's webinar, and after the webinar, our attendees will get a link to the recording. You get a copy of the slides from Ty, and we're going to run through a few things as people continue to join us just to help your session go smooth today. We are a small business development center hosted by the University of Houston-Victoria, and we serve 11 counties in South Texas. That's these counties that you see right here. In addition, we are part of the South Texas Southwest SBDC network, and that ranges from all the way from Brownsville to El Paso, out to San Angelo, to Austin, and all the way down here to Victoria. In addition, there are over 1,000 SBDCs across this country. You are never far from a small business development center. And if you are not within our service area, you just need to go to www.americassbdc.com to find your SBDC. If you're still not sure, you can always email me and I will help you find it. We are a partner with the Small Business Administration, and in addition, they help fund what we do here. And through their funding and funding from the state of Texas, we provide service to small business at no cost. It is no cost, confidential, and client-driven business advising. I will note that we are not the SBA, and our business advisors do not provide legal, nor do they provide tax advice. I have put information in your question box so you can see how to contact our center, take a look at our webpage, and just kind of find us out there on the internet. In addition, I am going to show you right here again. This is a picture of the building that we are housed in here at the Northwest Campus off of Airline. In addition, we provide a number of training programs that are offered at little or no cost. And everyone who attends today gets a complimentary copy of our email newsletter, but there's no obligation and you can unsubscribe at any time. Let me just go through a little bit of housekeeping. Up above where you see the video feed from my camera and from Ty's, you'll see this gray bar. Screenshot allows you to click and take a picture of the image that's on your screen. It will save it to your desktop with a generic name. My recommendation is at the end, go ahead and rename that so that you remember exactly what that screenshot is a picture of. In addition, this is your control panel that you see on the right side of your screen. Everyone today is muted. So there should be a red ring around your microphone icon. If you need assistance, you just click here, raise your hand. We do not have handouts for today, so you don't have to worry about, did I get a handout? Did I miss it? In addition, this is your question chat box. So go ahead and you can see we have the information in there for you to start you off on the right foot. And this is exactly the box that you're going to put your questions in for Ty. We will answer those questions at the end of today's program. If you're having trouble, the first step here is to log out and then log back in. If that does not work, we've included the phone number you can contact. Go to webinar support. Let me tell you a little bit about Ty Zeller. Ty is a certified business advisor too, and he has been with us since August of 2020. He covers Victoria, Jackson, Calhoun, and Aransas counties. In addition, Ty has practiced law for over 25 years, and he has practiced law in the areas of government, banking, real estate, nonprofits, and small business. He has served as the city attorney for the city of Port Lavaca and has also served as the municipal court judge for Port Lavaca. Ty has his bachelor's from the University of Houston, Victoria, as well as his master's degree, and he has his law degree from the South Texas College of Law. And with that, I'm going to take a virtual moment and turn this over to Ty.
Okay, thanks, Jean. I appreciate everyone registering and logging in, and we're just going to have just a few minutes this morning to talk about this very important topic.
Okay.
I need to show my screen.
There you go. Perfect. I'm going to hang out in the background then, Ty.
Okay, let me see here. All right, so the first thing we got to do, just like any lawyer would, is start out with a disclaimer. The SBDC does not provide tax, legal, or accounting advice. You can read that disclaimer. I am an attorney, but I'm not your attorney for legal advice. And you know, I hate even saying that, but what we want to do today is provide you with a little bit of education, a little bit of knowledge so that you can take it and be able to be educated when you do go to an attorney. You'll know what to ask, you'll know what the issues are. Mostly that you'll be able to spot those issues for sure. Contracts introduction. Okay, so it's a very broad topic. In law school, it's 2 semesters, 1 year about contracts, lots and lots of issues. We're going to be covering Texas law. Probably 90 to 95% of law, contract law across the nation is exactly the same from state to state. However, there are some differences. So we're going to be talking about Texas law today, but probably it will be applicable across the nation. For our purposes today, we're going to be talking about how you enter into a contract, what starts a contract, some illegalities of contracts, types of business contracts. You know what? They're all different types, and we run into them all day, every day in business. The bulk or the value of this presentation or the focus is going to be some common contract provisions. You know, who of us has ever read every word of a contract that you click on when you get cell phone service? Those are 15, 20 pages long, small print. You know, we just click on them and we go on. But you have just signed a contract by doing that. So we're going to be talking about some of those provisions. We're going to be talking about what happens if you default on your contract and what kind of remedies are available. There are some related courses that are very close to contracts that we may be offering in the future. Contract negotiation, I mean, that would be at least an hour long, probably more suitable for longer than that. Apart from being an attorney and a real estate broker, I'm a certified mediator, and I've seen a lot of contract negotiations. And you know, there's just a lot to the negotiation process, to leading up to the formation of a contract. There are franchise contracts that have provisions that are unique to that particular kind of contract. Employment contracts, normally professionals, people with licenses normally will have employment contracts. Teachers, nurses, doctors, sometimes engineers will have employment contracts. Normally it's white collar type jobs that have those contracts. Lease and sale contracts, equipment, merchandise, things like that. Sale of business contracts. We deal a lot with sale of business contracts here at the SBDC. We're able to go into those contracts, talk to you about provisions of those contracts, what's good, what's bad. and help you out with regard to that. Now, the Texas Deceptive Trade Practices Act is not a contract provision of the law. It is a statutory provision in Texas law that deals with deceptive trade practices. If you get sued as a business in Texas, either by a client or customer or by another business, you're probably going to be sued under the Texas Deceptive Trade Practices Act. Combined with that lawsuit will also be an allegation that you have breached your contract. So those are two different things. Normally they're combined in the same suit, and we're going to be talking about why that is important a little bit later. So the objective for today, I guess, would be so that you can feel more comfortable with the process of entering in or exiting a business contract. Now, we talk about exiting a contract. While you're going through and fulfilling a contract that you have as a business owner, you may realize that that contract is not economically feasible for you. For example, a cell phone contract. You've entered into a 2 or 3 year cell phone service contract with a provider. Another company comes along offering a better deal. You run the numbers and you decide that your current contract is not worth it. So you choose to get out of that contract. You choose to breach that contract. You pay the penalty, whatever the penalty is under the contract, and you go to the new contract. There's nothing immoral or unethical about breaching a contract. You just have to pay the damages, okay? So hopefully by the end of today, in the next few minutes, you will feel more comfortable about doing that. We want you to be able to make better decisions. We want you to avoid misunderstandings about your rights under the contract. All right, these are some of the contracts that you probably have as a business owner, even though you haven't thought about it. Software subscriptions, other technology, franchise agreements, construction agreements, partnership agreements. I have some very strong opinions about partnership agreements that we can talk about if you'd like. Sales related agreements, employment contracts, that's pretty big. Promissory notes, which is your promise and your contract to pay or somebody else's promise to pay you. Real estate contracts, either for the sale or lease of real estate. Equipment purchase, insurance contracts, and professional services. Okay, what contract used in your business is most important to you? So I believe you're going to see a poll that's going to pop up. And if you will select that from those 5 choices, we'll find out those results in a minute.
Okay, so we have popped a poll and it's on your screen. Go ahead and select what you feel is the most important business contract. And we've got some answers already. There is no wrong answer to this, I will say. But that's excellent. If everybody would just go ahead, we'll have it open for a couple more moments. And we'd really like to see what your opinion is the most important business contract to you. And we still got votes coming in. That's excellent. Okay, well, I think everybody has voted. So let me go ahead and close the poll. And now let me share those answers. So for your lease, we have 33% have picked leasing, 6% picked technology, 11% picked employment. The licensing contract is 11%, and 39% said professional services. That's really interesting choices. Okay, you're back to your slides, Ty.
All right, good deal. So, contract facts. First of all, what is a contract? For our purposes today, and it's kind of a layman's term, a contract is an agreement that the government or courts will enforce. Now, what does that look like? I mean, at the end of the day, at the end of the process, it could look like somebody with a badge and a gun coming out to your place of business and seizing equipment, seizing cash out of your cash drawer, putting a chain on your front door. I guess that is a possibility. It didn't happen very much. Could be somebody, a governmental entity, contacting your bank to seize your bank accounts. So a contract is an agreement that the government will help enforce for our purposes today. Most people don't read their contracts unless or until there's a problem, which is an issue. At the end of today, I would like for you to come out with the proposition that you should read all contracts. And you need to understand, at least generally, what it is you're agreeing to. Some contracts are negotiable, some are not. Now, in theory, every contract is negotiable. But at the end of the day, and for practical purposes, they're really not. For example, if you have a service business like AC service, you have 8 technicians that are going out into the community every day. You want to get them cell phones, a business cell phone for each one of them. So you contact Apple and you get the latest iPhone, and they tell you how much it's going to be, and you tell them, well, I don't want to pay that much. I'm buying 8 phones and I want a special deal. They may well, probably will tell you that it's either a take it or leave it deal. There's no negotiation in a deal like that. However, if you're Walmart and you have 25,000 managers across the country that you want to buy phones for, and you contact Apple and you tell them you want 25,000 phones, you probably can negotiate that price. So at the end of the day, some contracts are negotiable, some are not. The ability to enforce a contract is extremely important for a strong economy. That's why it's important to have a strong legal system. It's important to have specific rules that we can all rely on because it supplies certainty, and certainty reduces risk. My examples that I'm using today probably or maybe more consumer oriented because all of us have either bought a house or we've bought a car, but we may not even be in business yet. So it may be that I'm going to use more common examples. You have more protections as a consumer than you do as a business. You can contract away many rights as a business, many more rights than you can as a consumer. All right, first of all, formation. What's it take to form a contract? Well, let me just tell you, a contract being an agreement that the government will help you enforce, you can have an agreement that the government's not going to help you enforce. For example, you're out in your front yard, you're working in your yard, your flower bed, your neighbor comes over, your neighbor tells you that they're going to move. And they're going to put their house up for sale, and you say, well, I've always liked that house. My kids might want to live there. And your neighbor says, well, no problem. I'm going to give you first dibs on that house, on our house when we move. And you say, great. So you go inside, you tell your spouse, hey, next door neighbor is going to give us first dibs on that house. Now, between you and your neighbor, you have an agreement. That is not an agreement that a court will help you enforce for 2 reasons, and we're going to get to those reasons, but that's just an example of how an agreement cannot be a contract. Your first thing that it takes to enter into a contract is an offer, and that is a willingness to be bound by an acceptance. So if I tell you I will sell you my car for $20,000, that's an offer. That's an offer that can be accepted by you. However, that acceptance has to be a mirror image of my offer. In other words, if you say, I accept your offer, except I'm only willing to pay $19,000, that's not an acceptance. That is actually a counter offer, and the process starts over again. So any change in the offer of the person accepting it is actually a counteroffer and can't bind the seller. The third thing that we need for a valid contract is consideration. In other words, the money paid in exchange for the good or service. The exception of when you go through these 3 steps and you form a contract, the exception for that is illegality. When I say illegality, I don't mean like criminal illegality. I mean that a court will not enforce a contract, even though you've gone through these steps, in the event that there is an underage person that is one of the parties. Let's say, for an example, a 17-year-old high school student goes down to a car lot, used car lot, a buy here, pay here type car lot, and makes a deal. He brings $500 in cash with him that he has saved. The car lot owner, man, he makes a good deal. The 17-year-old signs the contract, drives away with the car. The 17-year-old misses his first payment. The car dealer tries to enforce the contract against the 17-year-old and tries to get a court to force the 17-year-old to make the rest of those payments. The court's not going to do that. 17-year-olds can't be legally bound to a contract. However, the car dealer can be bound. Even though the car dealer dealt with an underage person, the underage person can hold the car dealer to his contract. So keep that in mind. This is called a voidable contract. It can be voided by the underage person. It cannot be voided by the car dealer. Then we have capacity. If someone doesn't have mental capacity or they're intoxicated, they cannot enter into a contract. A contract cannot be enforced if somebody has been adjudged by a court as being mentally incompetent or if they're intoxicated. So you can't, if an intoxicated person walks into your business, you get them to sign the contract. That is not going to be an enforceable contract. Interestingly, these 2 elements are the elements that you can get a marriage annulment in Texas. Of course, everybody will say that they couldn't have been mentally stable when they married that person, but isn't that what they all say? So agency is another one. The agent that is signing for a business has to have authority to make that contract. Let's just say you have a equipment rental business. And you have always dealt with ABC Construction Company. In fact, they're a good client. Somebody comes in with ABC Construction on their shirt, and they say they want to rent a piece of equipment. They sign the paper and leave with it. The business contacts you and tells you they're not going to pay for that because that particular person was not authorized to enter into a contract on behalf of the company. In other words, that person was not an agent. Now, people can have implied authority to enter into a contract, such as if somebody comes in from ABC Construction and they have a card or that you know that they are the president of the company. A court would probably say that somebody with the title president probably has authority or it has implied authority to enter into a contract for that company. So there can be applied agency, but agency is one of those elements that can avoid a contract if the agent did not have authority to enter into the contract. Mistake, fraud, or distress. Now, mistake can arise a number of ways. There are cases where a person goes to a car lot, make a deal with a salesman. In fact, the salesman writes up a sales order. Everybody signs it, only to find out that that particular car had been sold an hour earlier and the title had been transferred. So it was a mistake as to who owned the car. The dealership didn't own it, therefore the dealership couldn't sell it. So it was a mistake, and courts will not enforce contracts that are based on mistake. Of course, they are not going to base on fraud and duress. In other words, somebody is threatening your family. If you don't sign this contract, we're going to do X, Y, Z. We're going to come by your house and do this or that. That's signing a contract under duress. That's not going to be enforceable. Contracts against public policy are not enforceable. Public policy would be contracts dealing with sexual acts, child labor, and gambling. So the government's not going to help you collect your gambling debts. At least in Texas, they're not. There are other ways that contracts don't ever form. Those have to do with the statute of frauds. The statute of frauds is a statute in a law in every state that tells you how long you have to file a lawsuit on your contract. If nothing else is said about your contract in writing, then the statute of frauds for a contract is 4 years. So if you have a contract and that contract is breached, the non-breaching party would have 4 years to bring a lawsuit to enforce that contract. We're going to be talking a little bit how that can be modified, but certain contracts have to be in writing. 1 year, contracts that cannot be completed within 1 year. So a lease agreement that is a year and a day would not be enforceable if it's not in writing. Contracts for the sale of goods over $500 need to be in writing. Contracts for real estate need to be in writing. So the agreement that you had with your neighbor, that you get first dibs, which is actually a right of first refusal, that would be an interest in real estate, and that would have to be in writing. So that's one of the reasons why your agreement with your neighbor would not be enforceable. Also, if you agree to be liable for the debts of someone else, that has to be in writing. Now, there is another way to get out of contracts once they're formed. As a consumer, there are certain rules that allow you to get out of contracts if people come to your front door, knock on your door, and try to sell you alarm service or whatever. By statute, you can get out of that in Texas within 3 days if you give written notice. And notice is very important, something we're going to discuss in a minute. Negotiations, anchoring. If you're negotiating a contract, let's just say buying a car. One of those things is anchoring. You say a low price, or you're selling a car and you say a high price, and you're the first person to say a price. You have anchored that price. Now, the other person's not going to agree to that, but the tendency is for the final price to drift back toward the anchor. So there is something to be said for saying the price first. There is something to say for lowballing, I guess you could say. But that's called anchoring. Just keep that in mind. The other party consideration, you need to be able to communicate. Find out what the other party considers important. The example that's given all the time in all mediation courses and the like is about the orange. Two people are arguing over an orange, and they take it to a wise judge, and the judge cuts the orange in half and splits it between the two people. Well, as it turns out, if they had communicated, they would have found out that one of the parties just wanted the meat of the orange, the other party just wanted the peel of the orange. And therefore, neither party got what they wanted. But if they would have communicated about the other party's consideration, they both would have gotten 100% of what they wanted. One of the little things to remember, but finding out what the other party considers important is a big deal. Turning the tables. So if you're out on a car lot, again, a consumer example, you go back and forth, you're not making any room, any movement. The salesman may use this technique and say, okay, what's it going to take for you to buy this car today? So now he's turned the tables on you. And if he can get you to answer that question, you have set a boundary on the price negotiation. Of course, you could use that on him as well. You could say, well, what's it going to take for you to sell me this car? And then if he answers that question, you've set a boundary on that. So once you set that boundary, you can't go out. You're not going to be able to go outside that boundary. So it's a very effective negotiation technique. Always ask for something in return. If I tell you, okay, yeah, I'll go ahead and take your offer of $19,000 for my car, but I want a year of oil changes with that. The mere fact that and I've seen this happen a lot, the mere fact that you said, okay, I will take your offer, puts the other party in a good mood, I guess you could say. Puts him in an agreeable manner to where the extra that you're asking for in return, the oil changes, they may well just go ahead and agree to that. So just some negotiation techniques for you. All right, now the bulk of, and I hope that the value that you get today by spending your time here with us, this is where it's going to be in our contract clauses. First of all, one of the important things that you're going to see is the choice of law or venue. This is really important. Okay, you're going to see this in any kind of contract that is written. This agreement shall be interpreted under the laws of the state of California. Any litigation under this agreement shall be resolved in the trial courts of Los Angeles County, state of California. First of all, choice of law. You'd never want to agree to be bound by the laws of another state. That is one of the, well, courts in Texas hate trying cases under the laws of another state because it's new territory. Okay, so if at all possible you want to strike this language and you want to strike California and put the laws of the state of Texas. Okay, now that's choice of law. Okay, now venue is where a case can be brought. You want to be able to bring a case in the state of Texas. You don't want to have to go to Los Angeles. That increases your cost greatly, and the complexity is much more. So you want to be able to bring the case in Texas, preferably in your county of residence, where you reside, where your business is. That's the preferable place that you want. Okay, so you'd want to strike Los Angeles County, state of California to Victoria County, Texas, something like that. Indemnity. The indemnity is extremely important. Indemnity is like a promise. Okay, a promise to do something. This comes up most of the time in construction contracts, whereby a landlord hires a contractor to complete a project on their premises. The contractor comes with his subcontractors. One of the subcontractors causes some damage, maybe causes some injury. The landlord doesn't want to be liable for those subcontractors that he doesn't have a contract with. So he requires his contractor to indemnify him. So the main contractor is going to indemnify the landlord, and which basically says, I agree, if you are subject to any liability, I'm going to take care of that. Now, normally the way they take care of it is with insurance. Also, the contractor may want to have the landlord indemnify him, because the landlord may have other contractors out on the premises. And when contractors start working together, a lot of things happen, a lot of accidents happen. So the landlord may want to be indemnified, the contractor may want to be indemnified. So it's a promise to take care of the liability caused by somebody else. That's basically what it is. So you need to, when you come to that in your contract, you need to read that, make sure you can live with that. Attorney's fees. Normally, cases for breach of contract in Texas, you can collect attorney's fees. It's not a given. In other words, even if you win or you think you win, that doesn't mean you automatically get attorney's fees. Attorney's fees provisions often read like this: in the event of litigation relating to the subject matter of this contract, the non-prevailing party shall reimburse the prevailing party for all reasonable attorney's fees and costs resulting therefrom. This is what you want to see in your contract. Don't rely on state law. State law allows judges to make that decision, allows judges to split the attorney's fees. But if you have it in your contract, then that is kind of what the law is. Warranties. A warranty is a promise to do something, not like an extended warranty like on an appliance, but in a commercial contract, a warranty is a promise to act in a certain way. In this provision, a contractor warrants that it will perform all services required in accordance with the prevailing standard of care by exercising the skill and care normally required of individuals performing the same or similar services under the same or similar circumstances in the state of Texas. The standard of care may be different in California than it is in the state of Texas. So if you have a warranty provision in your contract, you want it to say the state of Texas, because that's kind of the standard that you want to operate under. That's the standard that you want the other party to operate under. All right, now time is of the essence. This is kind of important in that when I graduated from UHV and was signing up for law school, went and entered into a contract for an apartment. I sat down, looked at the contract for the lease for one semester, had a big bold print: time is of the essence. And, I was uneducated at the time, and I thought, well, time is of the essence. That's kind of a whimsical phrase, sort of like seize the day, But time is of the essence has a specific legal meaning, okay? If you've ever bought a house, you have signed a contract that had an option period in it. If you've bought a house, you paid an extra $100 or so to have like a 10-day option period where you can back out of the contract for any reason. On the 11th day, that option goes away. It is no more. In that provision, that option provision, time is of the essence. So that is a hard deadline. Now, in that same contract that you signed, there is a provision where time is not of the essence, and that would be the closing date. Now, normally, time is not of the essence when there are a number of third parties in the mix that you can't control. like appraisers, surveyors, title companies, lenders. Though all those people may not be on the same page, they may not be on schedule. So if you're having to depend on a lot of outside people, time may not be of the essence, but you still, as a party to the contract, you have to use your best efforts to make it close on the closing day. So it can be time is of the essence or time is not of the essence. Okay, I'm missing some of my clauses. So let me talk about dispute resolution. Okay, dispute resolution, you will see that in just about any written contract that you have. Dispute resolution could be mediation or it could be arbitration. Mediation normally is an informal meeting with a mediator, where the mediator tries to find out common ground between the two parties and to get them to agree to a certain common ground. Arbitration is normally a binding, more like a trial situation where a retired judge sits, listens to the evidence, and enters a decision. That decision is normally binding and it is non-appealable. So contracts with large corporations like Apple, like AT&T, any kind of large corporation, they're going to want binding arbitration. If you agree to a contract with binding arbitration, you're giving up your right to a jury trial. You're giving up your right to bring a lawsuit in the case. Many times this binding arbitration provision cannot be negotiated away. You would have to have some significant economic clout to negotiate that away. Just know that that is what you're agreeing to do if you agree to that dispute resolution or binding arbitration provision. Integration clause is another clause that you'll see in contracts. Let's say you're out on the car lot again. The salesman's trying to get you to agree to to make a deal. He makes a deal with you and says, yeah, I'm going to give you free gas for a whole year. I'm going to give you oil changes for 3 years if you'll do this. You go in, you sign on the dotted line and all. You come back a week later for your oil change. It doesn't happen because the owner, the sales manager, says, no, we never agreed to that. And you say, well, your salesman agreed to it. And then the sales manager pulls out the paperwork and you have signed an agreement that has an integration clause. The integration clause is going to say something like this. This agreement and the exhibits attached hereto contain the entire agreement of the parties with respect to the subject matter of this agreement and supersede all prior negotiations, agreements, understandings with respect thereto. And this agreement may not be amended, may only be amended by a written document executed by all parties. That's an integration clause. In other words, it doesn't matter what you've been promised. If it's not in the contract, you don't have it. Waiver or non-waiver provision. Let's just say you sold a piece of equipment to another business and you're going to take payments. You agree to take $1,000 a month payments. You're rocking along for 6 months, you're getting your payments. Month 7, you don't get your payment. You know, you don't say anything about it because you have a lien on that piece of equipment, so you let it slide. Month 8, the business catches up on their payments and they rock along to year 2. Year 2, you don't have such a good relationship with them anymore. You've had words about other things. They miss another payment. Well, you want to foreclose on that piece of equipment. You want to send somebody over to get it. They say, well, you can't do that because you let us get away with it a few months ago. You let us slide and you waived your right to foreclose on this property for a mere 1 month lapse in payment. That would be a waiver. So you're going to see clauses that say non-waiver provision. And the non-waiver provision is going to say, the failure by one party to require performance of any provision shall not affect that party's right to require performance at any time thereafter, nor shall a waiver of any breach or default of this contract constitute a waiver of any subsequent breach or default or a waiver of the provision. So you could tell the person, if they missed a payment, you could tell them, okay, that's all right for this month. And if you have that provision in your contract, you can, in year 2 or 3, enforce that particular provision. Okay, severability. If you see a severability clause, there's some older cases talk about written contracts where one of the provisions, it turns out, is non-enforceable. It may be illegal. The old law was that if one of the provisions is illegal or unenforceable, then the whole contract gets thrown out. Well, severability clause is going to prevent that. It says something like this: if any provision of this contract is held unenforceable, then such provision will be modified to reflect the party's intention. All remaining provisions of this contract shall remain in full force and effect. Okay, so that keeps that from happening. It keeps the bulk of the contract in force. Notice. A notice provision is extremely important. If you've ever bought a house, there's a big section in the contract that has a place to fill in for notices. It has a name and address, it has email address, even has telephone number. That's the notice provision. There are many things that you would have to give notice of. In other words, if you, in your option contract example, you wanted to give notice that you exercised your option to get out of the contract, well, you have to give notice to the other party somehow. And you have to know where to give them notice and how to give them notice. And if you don't give them notice correctly, then you haven't exercised your option. The only way for you to know for sure is to look in the contract and see the notice provision. Many people leave the notice provision blank. I've seen real estate contracts that have the notice provision blank, and I'm just wondering, where are they going to send that notice if they have to send it? We already talked about the statute of limitations with regard to contracts. You have to bring an action on a contract within 4 years unless there's a provision in the written contract that changes it. A provision like that would say the parties agree that any action in relation to an alleged breach shall be commenced within 1 year of the date of the breach. Okay? Businesses can agree in contract to change the statute of limitations. That's why it's important to read your contract and to know what it is you're agreeing to. There is a provision called a force majeure provision. Force majeure. You'll see that and you'll wonder what it is. It's a French term that means superseding force. Sometimes we call it acts of God. Most written contracts are going to have a force majeure clause. What that does is it allows a party to get out of a contract or to modify a contract because of the acts of God. Now, we found out in COVID that a lot of these force majeure clauses were written too narrowly. So modern, like contracts written right now, are normally drafted to be more broad. This is an example of a broad provision. Neither party shall be responsible for any failure to fulfill its obligations hereunder due to causes beyond reasonable control, including without limitation acts or omissions of government or military authority, acts of God, shortages of materials, transportation delays, fires, floods, diseases, labor disturbances, riots, or wars, provided that it gives notice to the other party of its invocation of this provision. Notice it says diseases. Force majeure clauses prior to COVID, a lot of them didn't say diseases. It said acts of God. In the cases that were filed based on this contract provision, basically we're asking courts to interpret what was an act of God. Was COVID an act of God? Cases are all over the place on that. So modern force majeure clauses need to be very specific. If you're counting on getting out of a contract based on your inventory disruptions or something like that, your labor disruptions, make sure that your force majeure clause is more broadly written. Liquidated damages clause. Liquidated damages clause is well, the where you're going to see it the most is a late payment penalty. If you sell a piece of equipment, $1,000 a month payment, the company is 6 days late. There's a 5% penalty. That makes sense, right? 5% is presumed reasonable. You could, as a business, put in 10%. However, the burden would shift to you to be able to, for you to prove that 10% was reasonable. Under the law, 5% is reasonable, and it's presumed to be reasonable. In other words, it can't act as a penalty. On your $1,000 a month payment, your contract can't say, if you miss by 1 day, you owe me $1 million. That would be a penalty, okay? And that is not reasonable because it has no reflection on the additional cost for collecting that late payment. There are other liquidated damage clauses, such as in construction contracts. You contract to build a building. The contractor, the builder, has a certain number of days to complete it. He has a certain number of rain days. If he goes beyond that, he's going to owe the landlord a certain amount of money. And that has to be reasonably related to the cost to the landlord for that delay. There's time is of the essence. Okay. All right. Default remedies. If a party defaults, there are two types of remedies. There's money damages that make up for the default, and then there's equitable damages to make up for the default. First of all, money damages. Money damages makes one whole under the contract. Somebody promises to pay you $10,000. They don't pay it to you. The court orders them to pay what they haven't paid. That's a simple example. It makes one whole under the contract. That's called money damages. It normally will provide the benefit of the bargain. The measure of damages is usually the difference between the value of the contract and the market value of what's already been received. So that's money damages, where you make up for your breach by paying money, sort of like our cell phone service contract breach we talked about. There are equitable damages. The first one would be injunction. Injunction is a court making you do something. Keeping you from doing something. Let's say you had an order for 1,000 widgets. The supplier sent you 2,000 widgets, and so you've got an extra 1,000 widgets, and you don't want to give them up. The vendor sues you for that. A court could enjoin you or keep you from doing anything with those 1,000 widgets until something could be decided how they could get back. That's an injunction. Specific performance is forcing you to do something. Normally, specific performance is for unique goods or services, like real estate. If you contract to sell your house, a court can order you to follow through with that contract. Let's just say you're the seller and you just decide you don't want to sell anymore. There's a provision in your typical real estate contract that says that specific performance is one of the remedies. A court could order you to go through with the sale. Specific performance is not available for personal services. A court could not order a surgeon to perform a surgery. A court could not order an artist to do a portrait, for example. Another example of an equitable remedy would be rescission. In other words, rescinding the contract. Pretending, I guess, as if the contract never existed, and the court making orders that put everybody back in their place. There is a general rule of contract law called mitigation of damages. The non-breaching party has the duty to lessen or mitigate their damage. In other words, let's just say you hire let's use the wrongful termination. You have a employment contract. Your employer wrongfully terminates you, breaching that employment contract. You have a duty to go out and try and get comparable employment. You can't just sit on your hands and wait for the trial in 2 years and then claim damages for 2 years of lost wages. The court is going to require you to make reasonable efforts to find similar employment. If you don't, then the other party could claim that you have not mitigated your damages, and they would want a discount for that. A roofer, you hire a roofer to come out and fix the roof on your business. The roofer comes out one day, tears your current roof off, doesn't show up the next day, doesn't show up day 2 or 3. You know that there's a rainstorm headed your way. You're required to get that roof covered so that you don't sustain additional damage. You can't just sit back and let the rain run through your uncovered roof and damage your furniture and your sheetrock and everything else, because the roofer is going to claim that you have not mitigated your damage. Just another example of mitigation. Mitigated damages, liquidated damages. Excuse me. If you hire a contractor to paint your building because you're going to have a big celebration at the end of the year, the contractor doesn't do it. The celebration day comes, you have your celebration with an unpainted building. How would you put a dollar amount on that? It's very, very difficult. So in that situation, you would put a liquidated damage provision in that says if the building isn't painted by such and such a date, there is a $5,000 penalty or something like that. So it has to be difficult to estimate, but it also has to be reasonable as far as what it's worth. Those two kind of conflict a little bit, but that's usually a liquidated damage provision. Cannot be a penalty. Hiring a professional. All right, let me say this one thing, that you need to have insurance, okay? Now, let me tell you this. Normally, breach of contract actions are not covered by insurance. It's not covered by professional liability insurance. It's not covered by general liability insurance for your business. So if a vendor, if another business, if a customer sues you for breach of contract, you're probably not going to have insurance coverage for that, okay? Now, if you're sued by a customer, you're probably going to be sued for Texas Deceptive Trade Practices violations. Insurance will normally cover those kind of actions from a customer. So, and those two things are in one lawsuit. So it's important for you to have insurance that covers the Texas Deceptive Trade Practices Act, because the lawyer probably is going to end up representing you on both of them because they're both together. So another good reason to have insurance. One of the big pluses to having insurance, Normally, the biggest expense of an insurance claim is legal representation. Under your professional liability insurance, under your general liability insurance, the insurance company is required to provide you with an attorney, which is normally the biggest expense. Just talking to an attorney, don't feel like you need to hire an attorney for general questions. Everybody that's in business normally will be or could be part of an industry or trade organization. National Association of Realtors, they have one of those. National Restaurant Association. I think food trucks can even be a member of the NRA. National Federation of Independent Businesses. This is their website. All of these trade organizations have teams of attorneys that answer general questions for their members. Now, you would have to be a member, and you would call them up and ask them your general contract question or general business question, and they would give you general legal answer, not specific to your specific situation, but a general legal answer to your question. This is a list of the trade organizations that you could go to. It's not an exhaustive list, but there's probably going to be one on there that applies to you. Call them up and ask them. You don't have to run and pay an attorney every time you have a question. Start with these trade organizations. These trade organizations on their website, they will have a frequently asked question section. A lot of times your question is going to be on there. So I would advise you to check these out first. Then if it gets more detailed, you could hire an attorney for the answer. We're probably not going to have time for questions, and I'm sorry about that, but you have my information. This is my phone number. This is our web address. You can give me a call, send me an email with your questions. I'll be happy to get back with you. The biggest complaint against attorneys is they don't return phone calls. When I got out of law school, the first firm I went to work with, they had a very hard and fast rule that you will return a client's phone call by the next business day. Clients love that. So even if I don't have an answer, I'll get back with you and tell you I don't have an answer, but I'll get you one. So just feel free to contact us. You know, I know a number of people on here are our clients already. Some of you that aren't, you can become our client. Just contact us here. Okay, Jean.
Well, Ty, I want to tell you, probably one of the biggest benefits we have with you being on our staff is the fact that you can explain things in understandable language, because so many times when I see those terms, they just kind of stop me in my tracks because I don't really know what they mean. So thank you so much for sharing your knowledge with us today. We do not have any questions, which is not unusual, but folks, think about it. If you do have a question for Ty, you do have his contact information, and we'll try and answer your questions that way. For those of you who have stuck with us, we really appreciate you being here today. We appreciate you taking the time to be with us. And when you leave here today, your browser, or if you're on your phone, the app will pop to a 5-question survey. It takes just a minute to complete. And your answers on that survey are what drive what our training program looks like. So it's important to us. I do share your comments and responses with our presenter. Ty, we do have a question, and it was, will additional clauses be included in the presentation? Yes, we will have those slides so that you will have them when you watch the recording. And everybody will get a link to that today and a copy of the slides. You know, technology is a wonderful thing, but sometimes it does leave us in the lurch. But as I said, we're so glad everybody's been here today. And please, if you need something from us, use those contact links that we've shared and just reach out, because that's what we are here for. We are here to foster small business success. And thank you, Ty.
Okay.
All righty. Thank you, everybody. We will see you at the next webinar.